attorney fees based off the letter that was sent, if the decision was made to say, it's not worth chasing down, damages on trespass if we're not going to be able to get attorney fees. So it's just a decision to say this isn't worth it.
Objection.
And so I think that, but the claim itself, the underlying claim was reasonable.
Objection.
The trespass occurred, and
objection.
There's
Mr. Dyke, you can stop saying objection. I'm going to assume everything Mr. Tissot says you disagree with. Otherwise, we wouldn't be here. Go ahead.
So I think the underlying claim is reasonable. There was a debate about the amount of damages. There was a debate about whether or not we would be entitled to attorney fees. I'm not convinced that we wouldn't be entitled to attorney fees, but the risk didn't seem to be worth it. So I think there's a reasonable basis. I think, I think there's lots of arguments to say that the defendants are the ones who have been unreasonable and who have taken positions that are unsustainable, asking for, again, attorney fees that they didn't incur, that they, all the myriad of motions and discovery and all this stuff was all a waste, a very, very onerous on the plaintiff, and that, essentially that's the reason why we decided to dismiss. It's not worth trying to continue to litigate with Mr. Dock. He has the ability to really cause a lot of difficulty. So that was the basis for the dismissal. It didn't have to do with anything else. It was just a business decision to say, assuming we would get some amount of damages, which again I think that would have been the result if we had pursued it. There would have been some award of damages, but then having to collect on that, everything, it just wasn't worth it. So that was a reason to dismiss. I think that was reasonable on our part to dismiss. I think it was reasonable for Mr. Byers to bring the claim to begin with, and in the end he decided to dismiss. So I really don't think there's any basis under those factors to award any amount beyond the $325 that is the standard.
Mr. Duck, why is your proposed judgment the better of the two?
Can I stand up?
You can. It might make it a little more difficult for you to get on the recording, though.
First off, it is our position that this attorney knew who was in possession of the property from the very beginning throughout this dispute. He can claim, we believe, no mistake regarding possession. And when Tammy asked him about possession, he mentioned some assignment agreement. I believe he had the assignment agreement in mind from the very beginning. The Mears didn't want to get involved, and so he proceeded without them in a way that has no merit. The demand letter says you are threatening. He gives us illegal legal advice. Under the rules of professional conduct, I think 4.3, an attorney is not allowed to give a non-represented party legal advice. In his demand letter, he gives us his opinion of what the outcome of this will be. Potentially $25,000. We got into a dispute where all parties involved were not experts. We had a title. We tried to deliver a permission to use document. Right here, so Mr. Byers didn't have to worry about us trying to disrupt his regular use of the property. In an early email to Mr. Byers, I said, look, Mr. Byers, you have a warranty deed. That means you have title insurance. I tried to exhort him to file title insurance. And this attorney, I believe, colluded with Wasco Title for, I don't know, weeks, maybe months, to avoid making a claim to Stewart Title. So I believe if the truth is known, I believe if our discovery is allowed to go forth, it will be conclusive that there was bad faith and wrongful conduct on the part of the plaintiff's attorney. So I have, so there is, okay, regarding prevailing parties, my understanding it's a monetary evaluation. And I don't believe there is any monetary evaluation for Claim 1. If there was, we probably would have had the right to a trial by jury. And furthermore, how are they going to decide which of these heirs, or me or Heather, are supposed to pay the quiet title action against the whole universe? The quiet title action is against the whole universe. Anybody claiming interest against them.
And I'm not talking about the quiet title at this point. I'm just talking about the form of the particular judgment to deal with the dismissal.
Okay, well, he brought up Claim 1 and how it might factor in. We win 1, we win 2, they win 1, whatever. So from a monetary perspective, I believe we prevail monetarily. I'm sorry, could you repeat your question? Why is our form better? Okay. 3 times we tried to be conciliatory. From the beginning, we said we had learned enough about adverse possession by the time we got the lawsuit to say there is no money in the estate to contend it. It will be in Mr. Byers' best interest if we just don't do anything. They get the property, and he can, it said right on the summons, if you do nothing, they win. We believed it. We did nothing thinking that he would win. Everything would be fine. But then they didn't do the research. The attorneys didn't do the research. Maybe there was another deed involved. And so they had to refile it against me and Heather. They filed 3 claims against 3 defendants. My innocent wife has been charged and prosecuted for trespass. And she has nothing. She never set foot on that property. A shotgun complaint, 3 claims against 3 defendants. Tammy McLeod said, as it stated, it's a lawsuit of 3 claims against 3 defendants. So I lost my train of thought. I don't appreciate what's been done to my innocent wife and family. Lost my train of thought. Why is ours better? Well, one, I think if the evidence were all known, there would be clear grounds for wrongful conduct. Call it defamation, call it ORCP 17, failure to verify the merit of claims before filing papers. He says, we are the problem. We tried 3 times. We did. The plaintiff's attorney provided us a quit claim deed, and we signed it. The plaintiff's attorney said, if you concede the property and we drop it, would that be okay? And we said yes. But the plaintiff responded, no. We must have a monetary settlement on claims 2 and 3. They had an opportunity to drop this very early on, and they chose not to. And I believe that the truth is brought forth, these claims will be shown to have no merit and no legal basis. I'm not an attorney. I don't know if I will become one. But prevailing party fees, there's 3 claims, 3 defendants. They filed the amended complaint on the estate. Every document, every document shows the estate as a defendant. The notice to dismiss was served, I believe, on the estate in addition to me and Heather. So I believe the estate of Louis Nichols should be found to be a prevailing party on claims 2 and 3. And accordingly, my wife has suffered a lot. Is she not entitled to a prevailing party fee? Admittedly, I researched this thing, and that $5,000 is likely a cap. Fair enough. I didn't have time to labor this with an attorney. On that topic, we have consultations with attorneys. We never hired an attorney to draft any of these documents for us, but we have gotten their knowledge. We have sought the knowledge of attorneys and have paid for that. So why is ours better? Well, so if you were to look at the 2 claims, you've got 3 defendants prevailing on 2 claims, 5,000 times 6 is 30,000 plus the 325. Well, okay, you got 3 defendants. What if we weren't related? How would we divide that up? If the complaint was against unrelated persons and they prevail, and one said, well, I think I should get the 5,000. Another one says, well, why you? I suffered more than you did. So, you know, we wouldn't mind settling this whole thing, and we wouldn't mind walking away from this with prejudice, I guess. So if the plaintiff.
Let me see if I understand what you're saying, Mr. Dyke. You're saying that if the dismissal was with prejudice, you would be willing to agree to a judgment that awarded no cost, disbursements, or prevailing parties' fees to either side?
No.
Okay, that's not what you're saying.
No.
Okay, then I misunderstood you.
I'm saying if they were to accept our proposed form with the figures there, then we would consider dropping the whole thing with prejudice. Otherwise, we're looking at, I don't know how much litigation down the road. We're looking at wrongful initiation.
Okay.
We're looking at malicious prosecution. We're looking at abuse of process. So, I mean, I did the best I could with the knowledge I had to put this together. I'm not trying to hide anything. I'm not trying to pretend anything. I'm not trying to pretend that I paid $100,000. I mean, you want to talk about pretending? Look at the original complaint. Look at the demand letter. Mr. Byers is paying $100 a day. They threatened us with $100. They make it sound like Mr. Byers is having to pay for the mirrors to use some other property or something. They imply that he is writing checks for $100 a day, and that's proven to be false. And any more evidence, I don't think there's going to be evidence showing that he paid a dime. He's 100 miles away. I didn't disturb the stack of lumber, whoever that might have been on the property. So, you know, I guess that summarizes it. I mean, I'm not trying to hide things. I'm not trying to make up things. If he's agreeable, I don't know. If Mr. Byers is so sick, I don't have the money to afford attorneys. That's why I am suffering here. If he has a lot of money and just wants to say, you know, they suffered a year of this, I'm sick of it myself, what's this amount, you know, I don't care. You know, if he wants to do that, then that would be, please excuse me, that would be one nice outcome. Otherwise, we have ORCP 20.190, ORCP .105. And so obviously you can't claim attorney fees on 20.190 unless there's some other statute. And I contend that 20.105 is that statute. Ordinance. And those things necessitate the finding of merit, adjudication of merit and motive. So I desire an adjudication of merit and motive. And I think it's necessary in reckoning prevailing party fees. And I don't see how the court can complete its findings and conclusions without allowing our discovery to complete. You have made it plain that you're very careful, and I thought the lease agreement would be sufficient for reckoning possession, and the court has proven that it's not. So I don't know how much.
I want to clarify that. I don't think I ever found that it wasn't sufficient to prove that. Found that at the stage of the litigation with the motion that you filed, I wasn't able to consider it, which is a subtle but important distinction.
I've tried attacking possession every way I can.
I can't disagree with you. You certainly have. And as I've explained several times, I'm limited in what I can consider at what stage of the litigation.
And furthermore, in ORCP 20.
I think you're referring to ORS 20.
ORS 20.105.